welcome back to my channel. Previously I talked about the psychological evaluation report, its usage in federal cases. If you haven't seen that video, I'm going to put up a card just so you can take a look at that video. It is a little bit long, but I encourage all folks who are in a federal case to look over it because it can help your case in terms of mitigating. If it can present better options for you, even though it may not be something that's covered by your legal fees, or maybe a lot of out-of-pocket expenses, but it's very important. So I would encourage anybody who hasn't taken a look at that video to take a look. So the next step I want to talk about is that you've done some things while on pretrial, waited a lot of time, which is typically what most people in federal cases will do, just wait. Hopefully you're not in detention while that's happening, but if you are, it's when you get to a certain point where they're going to start setting your trial date, right? When it's getting close to the trial date, they're going to do a lot of hearings, and usually the ones that started off are evidentiary hearings that where your lawyer gets to see what the prosecutor, what law enforcement has been able to find. It takes a long time for your lawyer to actually sift through all that stuff and to come up with any issues that they've identified in terms of what was given or what was not given. During that kind of gathering and review of the evidence, your lawyer's probably going to start thinking about, well, should I have this person go through trial or not? That's one aspect. The second thing they're going to do is, well, can I get this case dismissed because based on the evidence or lack thereof, there isn't enough to sustain a case, and in which case they may file to dismiss a case, right? So, and if it's not that motion, it may be motion to exclude certain types of evidence. If your lawyer does not come up with a lot of motions to either, remove evidence, disqualify this or that, then they're probably along the lines of thinking about pleas, right? And to get a plea deal is not a bad thing. The statistic you probably heard that is that the U.S. Attorney's Office, their conviction rate on cases is, I think, 96%. That they pretty much, anybody that goes to trial, they're going to get a conviction. So defendants rarely can win a case in federal court. They say it's because they tend to have a lot more evidence already gathered, so the cases are strong, and that they would only proceed to indict and put people through cases that they are confident they're going to win. That's what they say, but but regardless of that, prosecutors still will want to make deals, because the expenses of trials nowadays is out of control. Whether it's having to interview hundreds of people for your particular case to get deposition and to enter into evidence for your trial, or to get those people to show up in court to testify, it costs a lot of money for both sides to actually to do a trial. And so regardless of how strong the prosecutor says their case is against you, it almost never means that they don't want to offer you a deal. Most of the time, when they don't offer you deals, probably with the most extreme case of like a terrorism case, for example. If you remember the Boston Marathon bomber, there was going to be no deal, because they knew that this was so severe that they wouldn't offer a deal. But with every other case, though, even in high level drug cases, they are willing to offer a plea deal, provided that do what they say, or give them the information that they want. Um, Getting a plea deal is not a bad. It's not always like a way to screw you as a defendant. However, getting to the plea deal is usually kind of a cat and mouse game that's played between your lawyer and the prosecutor. And the thing I've learned from my lawyer is that they see each other in the courthouse at least 2 to 3 times a week, right? They are seeing each other when they're walking down the hall from one case to another. They're going to say, well, how about my 3 other cases? Are you willing to offer me any deals just so I can get them out of the way? The prosecutor will say, well, how about you help me with these 2 cases, and I'll help you on yours. It's a very kind of transactional, very, I don't know if you want to call it negotiations, but the lawyers will keep going. So if they're going to say, if the prosecutor's like, I don't want to talk about this person right now, you come back next week and you ask them again. From what I've been told from my lawyer about my case, most of the time the prosecutor didn't want to talk about my case. They definitely did not want to reveal anything about what they want to do until the very, very end. Particularly because I wasn't very high on the totem. Apparently, that they had a lot of other big celebrity cases, big name cases that they were focusing on. So my case got continued for 2 years with no action, because essentially they knew my case wasn't a big shark that they were looking to catch. So that's something to think of. So when you're getting closer to your actual last time drop dead trial date, within 2 weeks, the prosecutor will start talking about deals. And it may have been your lawyer has always been steadfast and said, I only want this deal for my client, and then they'll say no. But the conversation if it's by 2 weeks from trial, will not stop. They will go back and forth, and with your lawyer is the boss usually, right? They're representing your interests. But with whomever is doing the prosecutor who's doing your case, they are typically not the boss. They are like the lowest level of the staff attorneys that are trying these cases. They need to go up to their bosses, usually 2 bosses, before they can get a deal signed off on. So in my particular situation, it did take 2 bosses. The first supervisor that my lawyer even went to and said, your attorney, your prosecutor here is not being reasonable. And so they went to the boss. The boss was like, of that attorney was like, we're not sure yet. And then they said, okay, well, if you want this deal, we're going to have to get the one person above. And so it went up pretty high for me to get my plea deal. I'll talk about kind of my plea deals and sentencing in a future series on videos. So I just want to talk about the process today and not so much about my own personal stuff. But so in terms of when you get a plea deal, generally no earlier than a month before your trial date. It's just not worth any of the lawyers' time, because they're under no kind of compulsion to actually settle at this point. Once you get closer to trial date, people will decide they want to talk, and you may even be brought into the conversation where they're going to ask you, they're offering you this, would you take it? Now, with pleas, the thing you have to remember is that they are usually one-shot deals. You can't really say, I want to kind of peck away at the conditions or terms of the plea deal. If you generally don't take it, then it's off the table, and then you just come back again. Defense lawyers will tell you have a limited number of times you can do that. You can't keep saying no and then want a better deal. You're just gonna have to at some point accept the deal that they're gonna put on the table, and I don't from what I've been told, it generally does not get worse. So if you were offered 10 and then you wanted 7, and then they were like, no, we'll do 8, and then you said, no, I want 5, the possibility of getting back the 8 is probably, yeah, you could probably get the 8 back, but if you wait too long, they're going to just wipe the deal off the table, and then you don't even have 10. So think carefully on that part, and it's the job of the lawyer to advise you what's the best course of action. So now, in terms of other aspects of plea deals that you should think of is if you have never been charged before in a crime, right? You can always plead down your current charges to a lower charge. Now, for this series, we're talking about the federal system, and because in the federal system, the punishments based by statutes are so high for many offenses that even though people may be charged with the exact offense that fits best in what their situation was, they can plead down to a lower charge that may not accurately fit your case, but they're willing to do that as a concession, the prosecutor, because the mandatory minimums or the maximum penalties for the lower charges is how they're going to get you your deal to have less time. That's usually something your lawyer will suggest to do first. They'll give them the idea of can we go from drug conspiracies, drug possession. Like it really is that is a negotiation part. It does require a lot of creativity to get there, but in the end, if there's a plea deal, they will typically plead down, because whatever charges you have now are probably very serious. They probably have mandatory minimums and very high mandatory minimums. The goal for pleading is to get down to a lower charge that either has no mandatory minimums, or that the mandatory minimums for the lowered charge is much less than your original charges. So that's the thing you have to remember. You're not going to be responsible for doing this part. Your lawyer is going to do all that for you. But remember, that's how negotiation happens. And I can tell you from my personal experience, it was hard to go through that process, because I actually was never allowed in the active conversation. I thought that you may personally be there when they're going back and forth, but no. Your lawyer will never let you in the same room as the prosecutor listening to them go back and forth, because those are kind of like their trade secrets, and they don't want us normal people to know. But they would come back. They would come back to me and tell me, this is what they're willing to offer. I only did that twice in terms of having to hear a deal and then having them go back. So that's the getting a plea deal. In my next video, I'm going to talk about the plea hearing, which is a completely different beast, because it's the part where you're actually going to get yourself into a courtroom, and you're going to use some of the stuff that you've drafted in the plea agreement. I'll talk to you about kind of how that works in the upcoming video. So if you're interested in this phase of the legal process, definitely hit subscribe so that you'll know when I post new videos when you click notifications. If you like this particular topic, definitely leave some comments. If I haven't answered anything that you may be wondering about plea deals, definitely put them in the comments. Hit like if you like it. That helps with the algorithms. Let other people see it. So I will talk to you guys soon. All right, bye.